Part 3, we're still on the Q&A from Attorney Riguera, 2020 edition. Who has exclusive and original jurisdiction over issues regarding the cancellation of certificates of land ownership awards, CLOAs, emancipation patents, and other titles issued under any agrarian reform program? Answer: the Department of Agrarian Reform Secretary. In 2009, Congress amended the Reprehensive Agrarian Reform Law through Republic Act No. 9700. Under the new Section 24, all cases involving the cancellation of registered emancipation patents, certificates of land ownership awards, and other titles issued under any agrarian reform program are now within the exclusive original jurisdiction of the Department of Agrarian Reform Secretary. He or she takes jurisdiction over cases involving the cancellation of titles issued under any agrarian reform program, whether registered with the Land Registration Authority or not. Secretary of the Department of Agrarian Reform versus Heirs of Redemptor. This is 2019 by Justice Leonen. How about Commission and Audit? DM Consinji, or DMCI, entered into a contract with the Metropolitan Manila Development Authority, MMDA, for the construction of an interim waste management project for Metro Manila. However, the project was not completed because of TROs issued by various courts and because the contract was not signed by then President Estrada. The MCI thus filed with the RTC an action for collection of 19 million against the MMDA, representing reimbursement for expenses incurred in the partial execution of the interim waste management project. The RTC ruled in favor of the MCI. May the judgment of the RTC be set aside? Yes. A liquidated claim against the government falls within the primary jurisdiction of the Commission on Audit. A liquidated claim is one which is determined or readily determinable from vouchers, invoices, and such other papers within reach of accounting officers. This case is one over which the doctrine of primary jurisdiction clearly held sway, for although DMCI's collection suit was within the jurisdiction of the RTC, it was the COA which had primary jurisdiction since the case involved a liquidated claim. The doctrine of primary jurisdiction does not warrant a court to arrogate unto itself authority to resolve a controversy, the jurisdiction over which is initially lodged with an administrative body of special competence. All the proceedings of the court in violation of the doctrine and all orders and decisions rendered thereby are null and void. Metropolitan Manila Development Authority versus DM Consinji, 2019 February. How about National Commission on Indigenous People, NCIP? Q. Respondents claiming to be the owners of an unregistered parcel of land in Talagag, Bukidnon, filed with the RTC in 2004 a complaint for action re invitatoria against the petitioner. The petitioners filed a motion to dismiss on the ground of lack of jurisdiction. The petitioners allege that they are members of the Talaandig tribe and that a certificate of ancestral domain title, or CADT, over the subject land was issued in their favor in 2003 by President Arroyo. They allege that pursuant to Section 66 of the Indigenous Peoples' Rights Act, or IPRA, it is the NCIP, not the RTC, which has exclusive and original jurisdiction over the case, as the subject matter concerns a dispute and controversy over an ancestral land, domain of Indigenous Cultural Communities, or ICCs, or Indigenous People, IPs. Should the motion to dismiss be granted? Answer is no. Section 66 of the IPRA provides for the NCIP's jurisdiction as follows. The jurisdiction of NCIP, Section 66. The NCIP, through its regional offices, shall have jurisdiction over all claims and disputes involving rights of ICCs or IPs, provided, however, that no such dispute shall be brought to the NCIP unless the parties have exhausted all remedies provided under their customary laws. For this purpose, a certification shall be issued by the Council of Elders or Leaders who participated in the attempt to settle the dispute that the same has not been resolved, which certification shall be conditioned precedent to the filing of a petition with the NCIP. A careful review of Section 66 shows that the NCIP shall have jurisdiction over all claims and disputes involving rights of ICCPs or IPs only when they arise between or among parties belonging to the same ICCP or IP. This can be gathered from the qualifying provision that no such dispute shall be brought to the NCIP unless the parties have exhausted all remedies provided under their customary laws. For this purpose, a certification shall be issued by the Council of Leaders or Elders who participated in the attempt to settle the dispute that the same has not been resolved, which certification shall be a condition precedent to the filing of a petition with the NCIP. Therefore, pursuant to Section 66 of the IPRA, the NCIP shall have jurisdiction over claims and disputes involving rights of ICCPs or IPs only when they arise between or among parties belonging to the same ICCP or IP. When such claims and disputes arise between or among parties who do not belong to the same ICC or IP, that is, parties belonging to different ICC or IPs, or one of the parties is non-ICCP or IP, the case shall fall under the jurisdiction of the proper courts of justice instead of the NCIP. In this case, while most of the petitioners belong to Talaandig tribe, respondents do not belong to the same IP or ICC. Thus, even if the real issue involves a dispute over land which appeared to be located within the ancestral domain of the Talaandig tribe, it is not the NCIP but the RTC which shall have the power to hear, try, and decide this case. Unduran versus Aberas, Turi, 2005 case, October. Q. The Section 66 of the IPRA confer primary or exclusive jurisdiction to the NCIP over all claims and dispute involving rights of ICCs or IPs to the exclusion of the regular courts? The answer is no. Section 66 does not state that the NCIP has exclusive jurisdictional or exclusive jurisdiction over all claims and disputes involving rights of ICC or IPs. Despite the language that the NCIP shall have jurisdiction over all claims and dispute involving rights of ICC or IPs, we cannot deduce primary sole NCIP jurisdiction over all ICCs or IPs claims and dispute to the exclusion of the regular courts. If it were the intention of the legislative that 1. The NCIP exercise primary jurisdiction over and or number 2, the regular courts be excluded from taking cognizance of claims and disputes involving rights of ICCs or IPs, the legislature could have easily done so, as in other instances conferring primary and original and exclusive jurisdiction to a specific administrative body. At best, the limited jurisdiction of the NCIP is concurrent with that of the regular trial courts in the exercise of the latter's general jurisdiction, extending to all controversies brought before them within the legal bounds of rights and remedies. Lim versus Gamosa, 2015 case, December 2, by Justice Perez. How about barangay conciliation? What disputes are required to undergo amicable settlement before the lupon of a barangay? So what disputes are required to undergo amicable settlement before the lupon of a barangay? Disputes between parties actually residing in the same city or municipality. So disputes between parties actually residing in the same city or municipality except PDG, RON, JVC, PAL. You have PDG, RON, JVC, PAL. That is, number 1, where one party is the government or any subdivision or instrumentality thereof, even if the government is just one of 3 or more parties, referral to lupon is still mandatory. Number 2, where one party is a public officer or employee and the dispute relates to the performance of his official functions. Number 3, offenses punishable by imprisonment exceeding 1 year or a fine exceeding 5,000. Number 4, offenses where there is no private offended party. Number 5, where the dispute involves real properties located in different cities or municipalities unless the parties thereto agree to submit their differences to amicable settlement by an appropriately pawn. 6. Disputes involving parties who actually reside in barangays of different cities or municipalities, except where such barangay units adjoin each other and the parties thereto agree to submit their amicable or differences to amicable settlement by an appropriate pawn. 7. Such other classes of disputes which the President may determine in the interest of justice or upon the recommendation of the Secretary of Justice. 8. Where the dispute arises from the comprehensive agrarian reform. 9. Labor disputes or controversies arising from employer-employee relations. 10. Actions to annul compromise jurisdiction or action to annul compromise judgment, not jurisdiction. Sanchez versus Tupas. 11. Any complaint by or against corporations, partnership, or juridical entities. Rule 6, Katarungan Pambarangay Rules, paragraph L4, or Supreme Court Administrative Court number 1493. That is Vida de Borromeo versus Pogoy. And 12, proceedings where relief is sought under RA number 9262 or the Anti-Violence Against Women and Their Children Act. Q. A, B, C, D, and E are siblings who are co-owners of Lot A in Rojas City. Their father allowed X to occupy the same provided X will vacate the property when needed by his children. X refused to vacate when asked to do so. Thus, A, B, C, in his own behalf and as attorney-in-fact of D&E, filed an unlawful detainer case against X. X moved to dismiss on the ground of lack of barangay conciliation since A, B, C, and X are all residents of Rojas City. A, B, and C argued that D&E are not residents of Rojas City. X contended that D&E had already executed an SPA in favor of C, who resides in Rojas City. May the complaint be dismissed for failure to undergo barangay conciliation? Answer is no. Here, the complaint specifically alleged that not all the real parties in interest in the case actually reside in Rojas City. As such, prior referral to the case for barangay conciliation is not a precondition to its filing in court. This is true regardless of the fact that D&E had already authorized C to act as their attorney-in-fact in the ejectment proceedings before the MTC. The residence of the attorney-in-fact of a real party in interest is irrelevant insofar as the actual residence requirement under the LGC for prior barangay conciliation is concerned. Q. For failure of the tenant X to pay rentals, A. The court-appointed administrator of the estate of Henry Datu decides to file an action against the former for the recovery of possession of the leased premises located in Davao City and for the payment of the accrued rentals in the total amount of $25,000. Is prior referral to the lupon necessary? Letter B. Supposing that referral is necessary, but the complaint is filed without such referral, may it be dismissed on the ground of lack of jurisdiction? This was asked in the bar 1991. Letter A. No. Prior referral to the lupon is not necessary. The Supreme Court has held that the barangay conciliation procedure applies only to disputes between natural persons and does not apply where one party is a juridical entity such as the estate of deceased, Vida de Borromeo versus Pugoy. Letter B. No. Lack of referral to the lupon is not jurisdictional but merely results in the complaint being dismissible for failure to comply with the condition precedent. Q. What are the instances where the parties may go directly to court without the need of prior barangay conciliation? Your keyword is papahid. Number 1, where the accused is under detention. Number 2, where the person has otherwise been deprived of personal liberty, calling for habeas corpus proceedings. Number 3, where actions are coupled with provisional remedies such as preliminary injunction, attachment, replevin, and support pendentilite. Number 4, where the action may otherwise be barred by the statute of limitations. Q. P filed with RTC a complaint for damages with application for preliminary attachment against D for physical injuries, arising from a vehicular collision. P and D are both residents of Las Piñas City. D filed a motion to dismiss on the ground that there was no prior resort to barangay conciliation. Should the RTC grant the motion to dismiss? The answer is no. Since the action was coupled with a provisional remedy, P may go directly to court. Q. Petitioner filed with the RTC of Davao City a complaint for nullification of deed of sale of land with prayer for preliminary injunction against the respondent. The petitioner alleged that he never signed the questioned deed of sale. The respondent filed a motion to dismiss on the ground of failure to comply with the condition precedent, that is, prior barangay conciliation. The trial court granted the motion to dismiss. It found that the petitioner's prayer for the issuance of a writ of preliminary injunction is a mere ploy to avoid the requirement of a barangay conciliation, as a simple annotation of a notice of dispendence would achieve the same effect without having to undergo trial or post a bond. Was the dismissal proper? The answer is no. Section 412 of the Local Government Code provides that parties may go directly to court where the action is coupled with provisional remedies such as preliminary injunction. As good faith is always presumed in the absence of proof of improper motive of the part of the petitioner, the lower court's assumption that petitioner was solely intent on evading the requirements of the LGC in applying for a preliminary injunction cannot be countenanced. A dismissal of an action cannot be sustained on account of an unproven assertion of bad faith. Rakpan versus Baroga. High, June 2018. Q. What is the venue of the barangay conciliation? If the parties reside in the same barangay, the said barangay. If the dispute involves actual residents of different barangays within the same municipality or city, the barangay where the respondent or any of the respondent actually resides at the election of the complainant. Number 3. If the dispute involves real property or interest therein, the barangay where the real property or the larger portion thereof is situated. 4. Disputes arising at the workplace where the contending parties are employed or at the institution where the contending parties are enrolled for study, barangay where such workplace or institution is located. Q. How shall objections to venue be raised? Objections to venue shall be raised in the mediation proceeding before the punong barangay, otherwise the same shall be deemed waived. May the parties agree to arbitration before the barangay? Yes. The parties may at any stage of the proceedings agree in writing that they shall abide by the arbitration award of the lupon chairman or the pangkat. Are lawyers allowed to appear at the barangay conciliation proceedings? No. In all katarungang pambarangay proceedings, the parties must appear in person without the assistance of counsel or representative, except for minors and incompetents who may be represented by their next of kin who are not lawyers. What is the effect of the amicable settlement and arbitration award? The amicable settlement and arbitration award shall have the force and effect of a final judgment of a court upon the expiration of 10 days from the date thereof, unless repudiation of the settlement has been made or a petition to nullify the award has been filed before the proper MTC within the said 10-day period. How is the amicable settlement or arbitration award enforced? The amicable settlement or arbitration award may be enforced by execution by the lupon within 6 months from the date of the settlement. It is not the sheriff or court officer who enforces the same, but the lupon itself. After the lapse of such time, the settlement or award may be enforced by action in the appropriate MTC. Q. Portia filed a collection case for $500,000 against Dina before the RTC of Manila, where both parties reside. Dina filed her answer raising the sole defense of payment. Pre-trial was terminated and the trial set a month thereafter. May the trial court before trial dismiss the case motu proprio, or upon motion on the ground of lack of barangay conciliation? Letter B. May the trial court before trial motu proprio refer the case to the lupon concerned for amicable settlement? Letter C. Assuming that the case was referred to the lupon and the parties agreed to a compromise settlement before the lupon, May the compromise settlement be enforced upon the lapse of 10 days from its date? D. How shall the compromise settlement be enforced? Answer to letter A, no. The defense of lack of barangay conciliation, which is a failure to comply with the condition precedent, was waived when it was not raised either in a motion to dismiss or in the answer. Question to letter B. Yes, while the trial court may no longer dismiss the case, it may, however, motu proprio refer the case to the lupon concerned for amicable settlement. Section 408 LGC. Proceedings in trial court shall be suspended in the meantime. Answer to letter C. No. Where the case was referred by the court to the lupon concerned, the compromise settlement will not have the force and effect of the final judgment unless it is first submitted to and approved by the court. Section 416 LGC. Letter D. Answer by filing a motion for execution with the RTC of Manila, the court which referred the case to the lupon. The judgment being a compromise judgment is immediately final and executory. Mila filed an unlawful detainer case against Fred for the latter's unpaid rentals in violation of the terms of the lease over a lot. Mila and Fred appeared before the barangay chairman's office for mediation, but the parties failed to reach a settlement. The lupon secretary thus issued a certificate to file the action, which was attested by the barangay chairman. No pangkat was constituted. Mila filed the ejectment suit before the MTC, which rendered the decision in her favor. Fred appealed to the RTC, which directed the parties to go back to the lupon for further proceedings and to comply strictly with the conciliation proceedings, and only upon failure of settlement may the records be remanded again to the MTC for the latter to decide the case anew. Fred appealed to the Court of Appeals, arguing that the RTC should have dismissed the complaint for being prematurely instituted instead of just remanding the court records to the MTC. Should the CA dismiss the complaint? The answer is no. While no pangkat was constituted pursuant to Section 410B of the Local Government Code, there was sustainable compliance with the law when the parties met at the office of the barangay chairman for possible settlement. Under Section 412, the confrontation either before the lupon chairman or the pangkat is sufficient compliance with the precondition for filing a case in court. Section 410 should be read in conjunction with Section 412. Lumbuan versus Ronquillo, 2006. Now we go to general provisions. Civil action is an action by which a party sues another for the enforcement or protection of a right, or the prevention or redress of a wrong. A civil action may either be ordinary or special. Both are governed by the rules for ordinary civil actions, subject to the specific rules prescribed by special civil action. Criminal action is an action by which the state prosecutes a person for act or omission punishable by law. Special proceeding, on the other hand, is a remedy by which a party seeks to establish a status, right, or a particular fact. What are the special civil actions? You can use QC, FID, creep. Certiorari, prohibition and mandamus. Number 2, review of decisions of COA and COMELEC. Number 3, expropriation. Number 4, ejectment, forcible entry and lawful detainer. 5, partition. 6, foreclosure. 7, interpleader. 8, declaratory relief and similar remedies. 9, coranto. 10, contempt. So, can a petition for judicial settlement of state be dismissed for failure of the petitioners to aver that earnest efforts toward a compromise involving members of the same family have been made prior to the filing of the petition? No. Article 222 of the Civil Code, now Article 151 of the Family Code, applies only to ordinary civil actions or suits, that is, an action filed by a person or persons against another person or persons. Article 222 does not apply to special proceedings, such as a petition for judicial settlement of state. Manalo versus Court of Appeals. Q. When an action deemed commenced, or when is an action deemed commenced? What is the importance of knowing when an action is deemed commenced? A civil action is deemed commenced by the filing of the original complaint in court. If an additional defendant is impleaded in a latter pleading, the action is deemed commenced with regard to him on the date of filing of such latter pleading, irrespective of whether the motion for its admission, if necessary, is denied by the court. Aside from the filing, it is also necessary that the requisite filing fees should have been paid. The importance of knowing when an action is deemed commenced, of course, is that such commencement interrupts or suspends the running of the prescriptive period of actions. Article 1155 Civil Code. If the action is dismissed, then the balance of the prescriptive period would start to run again. Q. B filed an action for collection against A. A filed his answer. P then filed a motion to admit amended complaint, including B as defendant. The court admitted the amended complaint. When is the action deemed commenced against B? Answer: from the filing of the amended complaint. In fact, even if the motion to admit was denied, the action was deemed commenced against B, and thus the prescriptive period had already been interrupted. However, upon the finality of the order denying the motion to the amended complaint, the prescriptive period would start to run again. B should now file the action to collect against B, assuming there is no res judicata within the balance of the period. May a complaint be filed by registered mail? If so, when it is deemed commenced. Yes, it is deemed filed or commenced as of the filing or as of the date of mailing. However, if the requisite docket fee was actually paid either personally or by mailing, subsequent to the mailing of the complaint, the date of such payment or mailing thereof shall be considered as the date of the filing of the complaint. Docket fees. Q. Plaintiff filed an action for damages in specific performance against defendant. The amount of damages sought is not specified in the prayers, although the body of the complaint alleged that total amount of over 78 million as damages suffered by plaintiff. The docket fee paid upon filing of complaint in the amount was computed at only 410 pesos, the action being considered to be merely one for specific performance and thus incapable of pecuniary estimation. Although the total amount of damages sought was not stated in the prayer of the complaint, yet it is spelled out in the body of the complaint, totaling in the amount of 78 million, which should have been the basis for assessing the filing fee. When the under-assessment of the filing fee was brought to the attention of the court, an amended complaint was filed seeking a reduced amount of 10,000. The trial court admitted the amended complaint upon the payment of the docket fees based on the 10,000. Was the admission of the amended complaint proper? No. All complaints, petitions, answers, and other similar pleadings should specify the amount of damages being prayed for, not only in the body of the pleading but also in the prayer, and said damages shall be considered in the assessment of the filing fees in any case. Any pleading that fails to comply with this requirement shall not be accepted nor admitted, or shall otherwise be expunged from the record. A court acquires jurisdiction over any case only upon the payment of the prescribed docket fee. An amendment of the complaint or similar pleading will not thereby vest jurisdiction in the court, much less the payment of the docket fee based on the amounts sought in the amended pleading. For all legal purposes, there is no such original complaint that was duly filed which could be amended. Consequently, the order admitting the amended complaint and all subsequent proceedings and actions taken by the trial court are null and void. Manchester Development Corporation versus Court of Appeals. Q. Private respondent is a holder of letters patent for his alleged invention, cocoa diesel fuel for diesel engines, and its manufacture. In 1983, private respondent filed a complaint with the RTC for infringement of patent with prayer for payment of reasonable compensation and for damages against petitioner, Philippines Shell Petroleum Corporation. There was no mention in the complaint of the amount of damages being claimed, but private respondent alleged, among others, that the conservative estimate of the combined gross sale of petitioner of private respondent's invention is 934,213 and 780 annually, computed at the rate of 20 million barrels, volume being yearly sold by the marketing arm of petitioner at the price of 2.93 per liter. Private respondent estimated the yearly royalty due him from defendant to be 236,572,350. Petitioner discovered that private respondent paid only as filing fee an amount of 252, based on his claim for attorney's fees in the amount of 200,000. Petitioner orally moved for the dismissal of the complaint for failure of private respondent to pay the correct filing fee. In 1985, the RTC issued an order denying the motion to dismiss but ordering private respondent to pay the additional docket fee in the amount of 945,600. Private respondent filed a motion for reconsideration of the order of the trial court requiring him to pay an additional docket fee, which the trial court granted by issuing an order allowing private respondent to pay the required additional docket fee after the prosecution of the case, to be deducted from whatever judgment in damages shall be awarded by the court. Did trial court act properly in allowing the docket fee to be constituted as a first lien on the judgment award? No. The rules clearly contemplate an initial payment of the filing fees corresponding to the estimated amount of the claim subject to adjustment as to what later may be proved. Conversely, nowhere can a justification be found to convert such payment to something akin to a contingent fee, which would depend on the result of the case. Under the circumstances, the court would stand to lose the filing fees should the party be later adjudged to be not entitled to any claim at all. Filing fees are intended to take care of court expenses in the handling of cases in terms of cost of supplies, use of equipment, salaries, and fringe benefits of personnel, computed as to man-hours used in handling of each case. The payment of said fees, therefore, cannot be made dependent on the result of the action taken without entailing tremendous losses to the government and to the judiciary in particular. In the case at bar, only the amount of 252, based on the claim of attorney's fees, was paid, but such is but a part of his enormous claim for royalties, reasonable compensation, which was not estimated, and the corresponding filing fees were left unpaid. Philippines Shell Corporation versus Court of Appeals. The Supreme Court remanded the case to the trial court with the direction that the case shall resume only after payment of the appropriate docket fee or upon proper application to litigate as an indigent. Q. A complaint filed for recovery of possession of real property also prayed for moral and exemplary damages, the amounts of which have been left to the court's discretion, and for actual damages, the amount of which shall be proven at the trial. The docket fees for the action involving the real property have been paid, but not those for the related damages, the amounts of which have not been specified. A. Did the trial court acquire jurisdiction over the case? B. May the action be dismissed? Number 2. Is the rule on the payment of docket fees in ordinary civil actions the same as that for the claim of damages which are impliedly instituted in criminal cases? This was asked in 91 bar. Number 1. Answer. Yes, the trial court acquired jurisdiction over the action. The Supreme Court has held where the docket fees for a real action have been paid, but the docket fees for related claims for damages were not. The court nonetheless acquired jurisdiction over the real action and may not dismiss the action for failure to specify the amount of damages. What the court should do is to merely expunge the claim for damages. Letter B. No, since the trial court acquired jurisdiction over the real action, it may not dismiss the same. What the trial court should simply do is to remove the claim for moral and exemplary damages which were not specified. Number 2. No, the rule for the payment of docket fees for damages is not the same as that for criminal cases. In criminal cases, docket fees for moral exemplary temporary nominal or mint damages are required to be paid only if the complaint or such information filed with the trial court alleges such damages. Q. P was a former record owner of 100 shares of stock in a Manila Golf Club. Upon his return from the U.S., he discovered that the shares in his name were canceled and new shares issued in favor of the National Steel Corporation. P filed an action against NSC and MGC to compel the assignment of shares of stock in his favor. P paid the docket fee for actions incapable of pecuniary estimation, which was only about 600 pesos. After trial, NSC filed a motion to dismiss on the ground that P should have paid the docket fee based on the value of the stocks sought to be recovered, and since the proper docket fees were not paid, the trial court therefore did not acquire jurisdiction where the proper docket fees paid. Should the motion to dismiss filed by NSC be granted? Letter A, no. An action to compel the assignment of shares of stock is an action for recovery of personal property rather than one incapable of pecuniary estimation. The docket fees should have been assessed on the value of the stock sought to be assigned to P. Letter B, no. The NSC was stopped from raising the defense of non-payment of the docket fee since it participated in the trial. The deficiency docket fee shall be assessed as a lien on the judgment award. Q. Harvest All Investment Limited, a minority stockholder of Alliance Corporation, filed an action with the RTC of Pasig to compel Alliance to hold the annual stockholders meeting ASM. The complaint alleges that Alliance refused to hold the ASM because Alliance wanted to hold first a 1 billion stock rights offering SRO. Alliance filed a motion to dismiss alleging that the proper docket fees corresponding to the 1 billion was not paid. Harvesol argued that the action is incapable of pecuniary estimation, since the purpose thereof is to compel Alliance to hold the ASM, and hence the payment of 8,860 docket fee for actions incapable of pecuniary estimation was in order. Is Harvest all correct? The answer is yes, depending on the nature of the principal action or remedy sought. An intra-corporate controversy may involve a subject matter which is either capable or incapable of pecuniary estimation. Here, the subject matter which is to compel Alliance to hold the ASM is one which is incapable of pecuniary estimation. That Alliance reason for not holding the ASM was to hold first the 1 billion SRO did not make the complaint capable of pecuniary estimation. D versus Harvest All Invested Ltd. March 2017 case. Q. Philippine Bank of Communications or PBCom filed a petition for extrajudicial foreclosure for the real estate mortgage executed in its favor by First Sarmiento Property Holdings. The real estate was auctioned and sold to PBCom as the highest bidder. First Sarmiento filed a complaint for annulment of the REM with the RTC. First Sarmiento paid the docket fees for actions incapable of pecuniary estimation. After the complaint had been filed, the ex-officio sheriff issued a certificate of sale in PBCom's favor. PBCom asserted that the regional trial court failed to acquire jurisdiction over First Sarmiento's complaint because the action for annulment of mortgage was a real action. Thus, the filing fees filed should have been based on the fair market value of the mortgage properties. The RTC dismissed the complaint for lack of jurisdiction, holding that First Sarmiento failed to pay the appropriate filing fees. Was the dismissal of the action correct? The answer is no. The complaint for annulment of cancellation of REM is incapable of pecuniary estimation. Even if the property had already been foreclosed when the complaint was filed, since the ownership and possession of the property remained with the petitioner. This is because at the time the complaint was filed, the certificate of sale was not yet registered with the Registry of Deeds. Q. May the trial court allow the payment by installment of the docket fee where the plaintiff pleads financial difficulty? Answer is yes. The Supreme Court gave its imprimatur to a Part payment scheme of the docket fee for a period of 2 years, which was well within the prescriptive period. The judge in this discretion may allow this part payment of the docket fee, especially where the amount of docket fee is large. In this case, the judge allowed an initial payment of $25,000 and then $20,000 every month until paid. The docket fees were in fact fully paid in 1 year. M. et al., as human rights victims, obtained a favorable judgment against the estate of President Marcos in the amount of $1.9 billion. They filed a complaint with RTC for the enforcement of such judgment, which has become final and executory. The Marcos state filed a motion to dismiss for non-payment of docket fees, which it argued should be based on the amount of the judgment award sought to be enforced. M. et al. Countered that an action to enforce a foreign judgment is incapable of pecuniary estimation. Hence, the rate of $610 is sufficient. Should the docket fees be computed based on the amount of judgment award sought to be enforced? The answer is no. Section 7, Rule 141, relied upon the RTC judge, covers only money claims against an estate not based on a judgment. Although the complaint may have been lodged against an estate, the schedule of fees for cases incapable of pecuniary estimation does not apply in the case at par. Nonetheless, for purposes of classification under the governing procedure rule, this foreign judgment may be subsumed under Section 7, letter B, number 3 of Rule 141, or class of actions not involving property. Mijares et al. Versus Ranada. Q. In the proceedings for the settlement of the estate of Alice, a contingent money claim for commission in the event of the sale of properties of the estate was filed by Allen with the probate court. The executrix moved for the dismissal of the claim on the ground that the docket fee under Section 7, letter A, Rule 141 was not paid. The RTC dismissed the money claim. Was the dismissal proper? No, the trial court has jurisdiction to act on a money claim even without payment of separate docket fees, because the probate court had already assumed jurisdiction over the proceeding for settlement of the estate of the deceased. Non-payment of the docket fee for a money claim is not a ground for its dismissal. The probate court should just order the payment of the docket fees within a reasonable time. Checker versus State of Shakur. Q. Are docket fees required for a motion to enter into the records an attorney's lien? For a motion to enforce attorney's lien? No. Docket fees are required for a motion to enter into the records an attorney's lien because this is merely an initial step involving the registration of the lien. However, a motion for the enforcement of the lien is in the nature of an action commenced by a lawyer against his clients for attorney's fees. As in every action for a sum of money, the attorney movant must first pay the prescribed docket fees before the trial court can acquire jurisdiction to order the payment of attorney's fees. Navarez versus Abrugar. Q. What are the instances when the docket fees need not be paid at the commencement of the suit? Letter A. Letter A. If the damages or claims arose after the filing of the complaint or initiatory pleading, or if the court awards damages not paid for in the complaint. Letter 2 or number 2, indigent litigant. Number 3, failure of the adverse party to timely raise the issue of non-payment of the docket fee. National Steel Corporation versus Court of Appeals. 4, civil action instituted with a criminal action where the moral, exemplary, nominal, and temporary damages are not specified in the complaint or information. 5, petitioner or a petition for a writ of amparo shall be exempt from the payment of docket and other lawful fees. 6, indigent petitioner for a writ of habeas data, exempt from payment of docket or other lawful fees. Note, in numbers 1 to 4, the docket fee shall be considered as a lien on the judgment award, while in numbers 5 to 6, the petitioner is exempt from the payment of docket fees. Q. Defendant obtained loans from Manila Bank evidenced by promissory notes in the total principal amount of $6,945,000 with interest. Defendant failed to pay the loan and was sued by Manila Bank before the RTC. The complaint prayed that judgment be rendered ordering the defendant to pay plaintiff the principal sum of 6,945,642 plus interest, penalties, and attorney's fees computed up to the date of actual payment pursuant to the corresponding promissory notes. Manila Bank paid the docket fee on the 6,945,000, but not on the interest, penalties, and attorney's fees. Judgment was rendered in favor of Manila Bank. May the judgment be set aside for lack of jurisdiction? Yes. Manila Bank argues that it could not have paid the docket fee on the interest, penalties, and attorney's fees since this could not have been computed yet at the time of the filing of the complaint, as the date of actual payment could not be foreseen. While this argument is true as for the interest, etc., occurring after the filing of the complaint, it is not so with those which have accrued as of the time of the filing of the complaint. Manila Bank could have easily computed the latter amounts and paid the docket fee thereon. Hence, for failure of Manila Bank to pay the correct docket fees, the court did not acquire jurisdiction to award Manila Bank's claims, and thus the case should be dismissed for lack of jurisdiction due to non-payment of filing fees. Q. Plaintiff filed a complaint praying for the recovery of sum of 450,000. Later on, the plaintiff amended its complaint by increasing the amount sought to be recovered to 600,000. Does the court have jurisdiction over the amended complaint? Yes. The lower court acquired jurisdiction over the case when the plaintiff paid the docket fee corresponding to its claim in its original complaint. Its failure to pay the docket fee corresponding to its increased claim for damages under the amended complaint should not be considered as having curtailed the lower court's jurisdiction, pursuant to the ruling in Sun Insurance Office Limited versus Asuncion. The unpaid docket fee should be considered as a lien on the judgment, even though plaintiff specified the amount of 600,000 as its claim for damages in its amended complaint. International Container Terminal Services versus City of Manila. Should the docket fees on a supplemental complaint be paid at the time of its filing, or should such fees be treated as the first lien on the judgment award? The docket fees should be paid at the time of the filing of the supplemental complaint. Otherwise, the supplemental complaint should be expunged. Of course, the original complaint on which docket fees have already been paid should still stand. Cause of action. Great, let's have this cause of action on our part 4. See you, and if you haven't subscribed yet to our channel, go ahead and hit that subscribe button. Let's study Remedial Law Review 1 and 2 together. Thanks.